Greetings, 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 greetings. It is I, King Clifford Jefferson, a son of Godfrey, the fifth Caliban Jew, the son of Folk, the ruler of Jerusalem. I'm the reincarnation of King Edgar the Peaceful, which we know here at the Third Temple English Church of England, reformed from the English Church of England as King Edgar the Peaceful, or also Jesus Christ, or the Vicar of Christ, or Melchizedek, King of Righteousness. It is January the 24th, 2025, which is equivalent to the birth year 2975. I greet you in the name of all the past ancestors, predecessors, successors. I greet you in the name of my Queen Sister Gobson from the House of Gobson, Archbishop Belmont from the House of Belmont, Countess Searcy from the House of Searcy, as well as all other officers here on staff, as well as you, Countess Middleton, for joining us today. Greetings to you as well. And anybody else who's going to show up today for this marvelous lecture, which is titled, New Jersey has committed malfeasance of office under the common law. New Jersey has committed malfeasance of office under the common law. And I'm going to relate that to the standing complaint that's filed in the Chancery Court in lieu of our reclamation and proclaim of the reversion of our estate on the benefit of those who have the estate entail, which we'll talk about that today as well. All right. So today is going to be a very, very informative lesson and keep you in the loop of where we're at with our case as filed before the Chancery Court. And this is the purpose and intent of this lecture, to show that on the decision made by the Chancery Court that New Jersey's officers, staff members, employees have committed malfeasance of office under the common law, which we're going to see as the purpose and intent of the Chancery Court's order for dismissal of my transfer complaint without prejudice as a result of her lack ability to deal with the common law of England, which she so eloquently said or stated that is not applicable within the courts of New Jersey, which is once again an error at law, as well as a prime example of what they call the malfeasance of office under the common law of England. This matter is now before the appellate court in regards to having the matter reverted back to the Chancery Court and having that Chancery Court judge removed as a result of malfeasance of office for violating the law, the common law of England, which is the only justification for dismissing the order to show cause, alongside the actual complaint filed on December 3rd, which we discussed today. All right, which is now before the appellate court, which is based upon an error of law. Error of law, error in law, and a mistaken fact. Mistaken law and a mistaken fact, which we're going to talk about today to let you know that we have not been stopped, we have not been altered, we have not been prolonged. We are still acting at the fullest capacity that we can at this point in time, with our claim in regards to reversion of our illustrious estate called the Kingdom of England. Okay, so with that, let's get started with this marvelous lesson, and it all entails what's going on not just on the state level, but on the federal level. Okay, on the state, but on the federal level, and all this is in regards to birthright citizenship. If you're not an heir, then you don't have not just a right to citizenship here, but you don't have a right to the estates that were left here for those heirs, who are in fact subjects dumbed down to what they now call citizens, all right, protected by that law, the law of the land, which is called the common law of England. And that's the only law that is to be used in regards to establishing who are in fact citizens by way of what we call birthright, including just sanguineous. Not just so, but just sanguineous. Because those who are just sanguineous are heirs. Those who are born on the soil by just soil are not heirs. They're just foreigners living on land as a result of what we're about to hear today from the mouth of Matthew J. Plankin, the New Jersey Attorney General, as a result of what's going on the federal level by way of the executive orders passed by Donald Trump, which will be affecting your area shortly if you are not or in fact, a citizen. Okay? Very, very important that you listen to today's lesson because it will be on your doorstep real soon. As you can see, the image behind me is symbolically a oath, all right, of office, a oath of allegiance, as well as the oath uh, to the trusteeship in which they inherited. Okay, very, very important. But as you can see, they got their fingers crossed. Okay, they got their fingers crossed. Let's see why. I realize this is an alarming time right now. So I'm asking all those who are members, who are viewers, to press this issue, all right, in regards to the return of your king, all right, who is the only person, all right, to prevent you from being deported, who is the only person who's able to restore this government. He's the only person is going to be able to restore the land back to its purest and pristine form. Okay? I'm going to prove it with this lesson. Okay? Let's get started. We're going to play a little bit from a narrative that I use as my template, you know what I'm saying, for the focal point of today's lesson. And this is straight from the Attorney General, Matthew J. Plankin, the Attorney General of New Jersey, in regards to defending their so-called understanding of what birthright citizenship is, which they lack clear understanding because their citizenship or birthright citizenship is not looked at or interpreted in the light of the common law. Okay? Of the common law. I didn't say that. That's what the Supreme Court said. Okay? So just look at it. I can play all of it, just some of it. They realize what's coming down the pipe. The cat's out the bag. You need to say this lecture and pass this on to everyone that you know. Okay? I don't care who it is. Very important. They know what's coming down the pipe. Let's see.
Would act in ways that were in the best interest of our community, of our residents, of our neighbors, of our friends. And I said very clearly that A, he's a duly elected president. No one makes any bones about that. And B, he's entitled to enact a policy agenda that he sees fit for the country. But at the same time, I made it equally clear that as the Attorney General of the state of New Jersey, I would stand up for the rule of law and for the rights of our residents.
He never said citizens. He never said citizens. All foreigners, just residents. And residents can be taxed. Okay? That's one of the characteristics of a resident, that which who can be taxed. Okay? That's not a common law right. A common law right is a substantive right which cannot be taxed. The founding fathers knew that taxation without representation is a violation of law. So how come we don't know that, or you don't know that? All right. So he's not talking about citizens. He's not talking about foreigners. He's talking about their employees. Okay? Because the only thing that you have to prove that you are, in fact, some type of resident is a driver license, a birth certificate, a standard ID card, or any other instrument that on the face of it does not state that you are, in fact, a citizen, as well as New Jersey Revised Statute Title 39, colon 29, dash, part sub, Title 39, colon 3, dash 29.3 of New Jersey Revised Statute, which clearly shows you that possession of that instrument or any instrument that they have is not evidence of one's citizenship or one's foreign statuses. All right, not one foreign status. And you got two type of statuses: political status and civil status. Okay, two of them: political status and civil status. Let's continue.
And when I took this job, I swore an oath to uphold the United States Constitution and the Constitution of this state. And I made a commitment to serve the people of the state of New Jersey, all 9.5 million of them. That's why today I'm announcing that New Jersey is leading a group of 18 states, the District of Columbia, and the city of San Francisco, in filing a suit to block President Trump's executive order eliminating birthright citizenship for many Americans. The executive order renders many children born on American soil without citizenship, creating for the first time a class of American-born children whose health and well-being are threatened by their own government. This is an extreme and unprecedented act, and this executive order is an assault on the rule of law. It attacks a right that is core to our nation's earliest days. It's an assault on the very text of the Constitution, a right that our nation made sure to codify in the 14th Amendment in the aftermath of the Dred Scott decision, one of the worst decisions the Supreme Court has ever issued, and following a civil war. So you got to remember, the birthright citizenship clause in the 14th Amendment followed the only brief period in American history where the descendants of slaves were held, even if they were born on American soil, were held not to be American citizens. We fought a bloody civil war, and shortly thereafter enacted 157 years ago the 14th Amendment, which put what had always been in the practice into the United States Constitution and deliberately took it out of the hands of presidents and elected leaders as to who would qualify for citizenship when born on American soil. But this isn't just an attack on the law. It's an attack on the very fabric of this nation, this diverse nation, a nation of immigrants. It's an attack on states like New Jersey, home to Ellis Island, in the shadow of the Statue of Liberty, that are built on the contributions of generations of immigrants. So many Americans who have poured blood, sweat, and tears into serving and defending this nation, including attorneys in this office, our law enforcement officers, military service members, our educators, our firefighters, our neighbors, our friends and families are themselves immigrants or our children of immigrants. This executive order is an attack on all of them, and frankly, on all of us. And I can think of nothing better that what epitomizes to uphold the Constitution and the rule of law than to defend the rights enshrined in the Constitution against this unlawful executive order. Now, we all have personal connections to immigrants. I remember very fondly going to Ellis Island as a kid and etching my grandparents' names. By the way, it was a misspelling. Plotkin was the original name. And then I stand here in Newark, where my family came, I'm sure never imagining that one day, a few generations later, I would be defending their very right to have that American experience. This is a state where my in-laws came from China. Ironically, we're going to talk about Wong Kim Ark. My father-in-law is from the same part, countryside of China that Wong Kim Ark was from.
That's
Opened
funny.
business here. Pretty easy. I did that business 364 days a year. Raised my wife and her brother, both of whom first generation American born citizens, who now is raising my two children just a few miles away from where those same grandparents raised my parents. That's the story of America, and everybody has a connection. And so when we talk about immigrant communities, when we talk about who these people are, we need to remember that they are all of us. They're not some people far away who we can demonize. They are all of us. They are who we are as a nation. So I am extraordinarily proud to lead this effort on behalf of an incredible coalition to block this clearly unconstitutional executive order. We're the first case to present our full legal briefing and argument to the court, and we hope for a swift decision confirming what we've known all along, that the 14th Amendment and the subsequent Supreme Court precedents that followed are crystal clear. That, quote, all persons born in the United States and subject to the jurisdiction thereof are citizens of the United States. There's no question that a child born in the United States to non-citizen parents are, quote, subject to the jurisdiction of the United States. We know it again from Wong Kim Ark, an 1898 Supreme Court case that forcefully rejected the position that the executive order now advances today. One that has been
all right,
repeated.
So that's it. All right. So the 14th Amendment is what Attorney General and his entourage are using to defend against the executive orders that were executed by the incoming president, Donald Trump. Okay. But within the language of his little dissertation, he focused on immigrants, okay? And he based the status of those immigrants based upon the clause of the 14th Amendment as amplified in United States versus Wong Kim Ark, okay? As amplified in United States Wong Kim Ark. But this is how they do. They cherry pick on what it is that they want to say. In their oral arguments, in their briefs, okay, in their altar calls, in their conferences, they cherry pick about what it is that they want to talk about, but not this time. Not this time. There's a difference between birthright citizenship of those who are heirs to this land and those who are foreigners to this land. Okay? And he clearly said all the subjects of New Jersey were residents, i.e., immigrants. All right? And he talked about all of us had a plot to play in this undermining of what the executive department under Donald Trump is trying to do in regards to the protection of those rights that were, I might say, undermined from those rights from the people who previously held those rights, which were in fact us. Those people identified now as Negro, blacks, coloreds, when they were in fact the English people protected under the common law. Because if the Supreme Court ruled in the United States versus Wong Kim Ark in regards to how citizenship is supposed to be determined of those now free emancipated slaves, not immigrants, all right? Not anybody that Matthew J. Plankin was talking about, but emancipated freedmen who were at one time free men and women, Okay? And the remedy that was created under the 14th Amendment for those free, emancipated individuals, all right, had a choice to make based upon what form of political status they're now going to take on. Was it a civil status provided by them or political status as provided by your nation? Okay? This is a question that they're going to be forced to reckon with. Okay? Because if you're looking at United States versus Wine Kimmel Art, that language strictly refers to the common law of England in regards to citizenship. Those who are nationals and those who will become naturalized citizen, which is the opposite of what we call a national. Okay? So he's lying to you. All right? He's got his fingers crossed. All right? I'm going to prove it. Let's see. United States versus Juan Kimmel Art. Just going to briefly look at this case on Wikipedia because I'm going to show you in my appellate brief, all right, entertaining the same subject matter in regards to who we say we are, contrast to who they think we are as naturalized citizens. We are not naturalized citizens. We are, in fact, national citizens whose rights were restored by the creation of the 14th Amendment, which must be looked at in light of what we call the English common law. They can do that with Juan Kimar, and they couldn't do that with Matthew J. Plankin. He only fall in one classification, and that classification, which those who are born on the soil, which don't make you a citizen because you're born here. Okay? Thomas Jefferson said, ignorance of the law in any country will wind up in the abandonment or somewhat the loss effect of that law. Okay? We must understand the language of United States versus Juan Kim of Art, which Matthew J. Plankin referred to, holdings referred to that citizenship clause, in spite of what was the argument raised with Juan Kim of Art, okay, he was not, his citizenship was not construed to the common law of England. It was construed to the 14th Amendment, okay, for those becoming naturalized. Those who were emancipated, protection at law or civil status did not come from the 14th Amendment. It came from the common law of England. Okay? Let's see. The citizenship clause of the 14th Amendment must be interpreted in light of the English common law. And since Juan Kim Art was not an English national, they had to construe him to some other form or process of citizenship known as naturalization, which was the process that they created under the Naturalization Act of 1790. Okay, but it had nothing to do with a genealogy or ethnology or even a political relationship. It had to do with a color of skin. We see that in Ray Ahmad Hassan, which is the district court ruling on how to interpret the Naturalization Act of 1790. Okay, in which we know that according to the 14th Amendment, Juan Kim Art was determined to be a naturalized citizen based upon the requirement that makes you a citizen by being a resident from for a certain amount of time. Okay, we must understand what's going on. So the English common law, in regards to the 14th Amendment, was based upon those who are emancipated from slavery. Juan Kim Art was not emancipated from slavery. Juan Kim Art took the naturalization process, which could not be afforded to him under the English common law because he was not, in fact, a English national. We must understand that. Okay, brothers and sisters? We must understand that. So with that, let's go to misfeasance of office, or non-feasance of office, or malfeasance of office. Okay, because he's holding the office right now, Matthew James Lincoln. The president holds the office right now. Okay, based upon their oath of office to that what? That supreme law of the land, the Constitution. Very important. Misfeasance, non-feasance, and malfeasance are types of failure to discharge public obligation existing by common law customs or statutes. Did you hear that? Hear that? Misfeasance, non-feasance, and malfeasance are types of failures to discharge public obligations existing by common law, custom, or statute. Okay? And yes, common law has a custom, common law has precedents, and common law has statute. It's called reception statutes. Okay? They're called reception statutes. Okay? Let's define these three terms. Non-feasance is the failure to act where action is required, willfully or in neglect. Non-feasance is similar to omission. Then there's misfeasance, is the willful inappropriate action or intentional incorrect action or advice. And then there's malfeasance, is the willful and intentional action that injures a party. Okay? Very important to understand all three in regards to the common law of England. The common law of England. Okay? To not violate, to violate the law is an error of a law or a mistake at law. Then there's also what we call a mistake in fact. If your fact is rooted in the law, then apparently you screw from due process of law from the very door. Okay? You can't examine the fact until we establish the law. Okay? Because the law establishes jurisdiction that gives the court ability to hear the matter based upon personam jurisdiction, which is jurisdiction over the person. All right? Very important that we understand these terms. Error at law. Error at law. A various type that may occur in legal proceedings and may or may not constitute grounds for appeal. Okay? Some errors might not constitute grounds for appeal, and some do. All right? Some do. And one of the greatest grounds for an appeal is what we call legal errors. Okay? A legal error is an error that results from a violation of the execution of the law or the interpretation of the law. Okay? Very important. The execution of the law and the interpretation of the law, which is mistakes in law and mistakes in facts. Okay? We must understand that. And we know the Attorney General is the executive officer of the executive branch. Okay? Very, very important that we understand this within this lesson. Okay? Let's get here. As I said, on January 16th, my Chancery Court complaint was dismissed without prejudice. It was dismissed without prejudice from the Chancery Court by Chancery Judge Louise, what's her name? What was her name? Lisa Vignulia. Okay? It was dismissed without prejudice. All right? To dismiss with prejudice is a claim that you cannot file again. A dismissal without prejudice is a complaint or a complaint that you can file. Okay, again, which I presume was a legal defect. Okay, all right, whether it was in procedure, whether it was in process, there was some type of legal defect which were grounds for a motion being denied or dismissed without prejudice versus a frivolous complaint. All right, that's filed and dismissed with prejudice because it has no legal ground on legal basis. This case was not dismissed with prejudice because it was malicious or frivolous, etc. It was based upon some legal defect that Judge Lisa Vignulia claimed that was defective, but there is nothing in the order about the defectiveness and the argument that I raised in the complaint, or else it would have been listed in this order. Okay, so let's examine the order and let's examine my appeal. We already went through the chancery complaint that was filed, all right, in regards to why the complaint was filed, and we're going to see that reiterated in this order from the Chancery Court judge, which is supposed to be responsible for what we call the king's consciousness. Okay? But once this conscience came back to her, she realized what position and what harm she was in as a result of recognizing who I was. Because if I wasn't who I was or said I was, or if the claim was invalid, it would have been dismissed with prejudice. It was not dismissed with prejudice. Okay? Matter of fact, the whole case was dismissed on the grounds of a motion that was an order to show cause and on the grounds to stay in the criminal proceedings against me, as well as stay in all deeds filed on the county clerk, as well as no land conveyances are to be conveyed in the state of New Jersey, as well as all escrow accounts dealing with any type of currency conveyance be stayed until we can actually find out who are the heirs that this property and the as well as the funds belong to, as well as establishing who actually owns what. Okay, in regards to land that's actually elodial. All right, and we're going to see that the language of the order is totally biased as a result of how we presented our claim based upon the law, which is the common law of England, which was totally ignored in the order, which gives it grounds for an appeal. Okay, which gives it grounds for an appeal. So let's look at it. I told you I'm gonna take you every step of the way. So we're gonna read the appeal and we're gonna read the order. Okay? We're gonna read the appeal and we're gonna read the order. Here's my appeal. Filed the day after the order was given. Here's my appeal. Right? I'm appealing the Chancery Division order. That's what I'm appealing. All right. We're gonna go through this real quick. Brief in support of the appeal. Okay? All this was done on behalf of your king. No help, no assistance whatsoever. Let's go to the order. Now check it out. Let me see. Let me upload this real quick. Show you how they shook from the king. They are actually shook. You got to be able to read between the lines. Okay? You got to be able to read between the lines. So let's do that. Let's read between the lines. Well, that thought. Okay. No. We're finishing a while. All right. Take you every step of the way. They come in. Yeah, here we go. All right. This is the court docket, everyone. As you can see, case caption, disposition date, January 16, 2025. Case disposition dismissed by court without prejudice. Okay, this tells me one thing, that this judge did not want to deal with this issue as a result of what it is that I was requesting, which we're going to read about in her order. She's going to tell you. All right, she's going to tell you. So she dismissed the complaint without the prejudice. All right, but the order that she gave was not based upon the complaint. It was based upon the order to show cause that was filed after the complaint was filed. Okay, so there's no order actually dismissing this complaint on the docket because, as we can see, the case docket is closed, but it's dismissed without prejudice because she knows it's going to be reopened when it's appealed. She just don't want to sign off on it because she knows if she does, it's going to be all hell to pay, and she knows it in her order. All right, watch the madness, brothers and sisters. Complaint file submitted by King Clifford Jefferson, the Crown of England, on behalf of Clifford Jefferson, the Crown Representative. All right, filed December 12th, December 3rd, 2024. Okay. Then there was a couple correspondence that I presented to the court. Then there was a motion for order to show cause why the criminal proceeding shouldn't be stayed as a result of them misidentifying me with that standard ID called a driving license, okay? Which, according to the statute, it says in the language of the statute that it's not proof of one's citizenship or foreign status. And we know that's the case, and we know that that judge don't want to deal with that because she never mentions this in her order. So keep that in mind as well. She never really dealt with why the motion order to show cause, which we know is called a court warranto. Same thing. Our ancestors called it a court warranto, but they called it an order to show cause. And the order to show cause was based upon everything that the court warranto demanded. Okay, which the judge realized that, like, wow, if I do get this man what he wants, that means that it's going to shut down whatever New Jersey is doing, and she can't be the cause of that, which is understandable. All right, it's way bigger than her. All right, so she had to take the what they call the least road of resistance, the path of least resistance. That's what she took. All right, was to dismiss it and have it appealed And then if it has to be remanded back, then she got to go ahead to do what she need to do. All right. But it won't be based upon her ignorance of the common law of England, because that's what she did. She made a decision which violates the common law of England, which means that she's in violation of malfeasance of office, because those terms, all three terms, originated from what everyone said, the common law. All right. As we can see, the certification of proof of service was submitted by me on the grounds of those being properly served. All right. And then the order to show cause, which was denied by that judge on January 16, 2025. Okay. She never denies the complaint, but she denied the order to show cause to stay until the complaint can be dealt with on behalf of the arguments brought forth in the complaint. She did away with all of it because, if she did allow these defendants to respond, i.e., the state of New Jersey and the Land Title Institute, they will be criminally penalized by her hands, i.e., her John Hancock. Okay, so she knows this problem is it has come to a head. She's just not going to be the one to sign off on it. Okay, as you can see, there's no order on the docket in regards to dismissing this complaint filed December 3rd, 2024, because the docket disposition said the case and the docket was closed on January 16th, 2025, the same day the order to show cause was issued by the judge, and dismissing the whole complaint entirely, relieving the defendants, i.e., the state of New Jersey and New Jersey Land Title Institute, from proving that they, in fact, have a better title than the Crown. And they know they don't, because why? The land is allodial. Okay? Under the statute, which is derived from the common law of England. Okay? You're going to hear this from the judge's order. All right? So let's review it now. If everyone understands so far, please give me a thumbs up in the chat. If you understand what's been said thus far, please give me a thumbs up in the chat. We got 8 comments, but I don't see nobody else but Brother Thomas and Countess Middleton. Where everybody else at? Everybody show up in the chat. Give me a thumbs up. All right. Superior Court, New Jersey, Chancery General Equity, Middlesex County, docket number, which is already being repealed. It's already before the appellate court. All right, let's read it. This matter has been opened by the court upon the application of King Clifford Jefferson pro se for an order to show cause seeking temporary restraints and preliminary relief, and the court has considered the moving papers and for good cause has shown. It is on this day of the 16th of January 2025 that order is as follows. Plaintiff's order to show cause is hereby denied. This order should be deemed served on all the attorneys of record upon its upload to e-courts. Now, the reason why this is done, we just said that it was dismissed without prejudice. Okay? And dismissals without prejudice result from either a defect in the actual complaint or a defect in the process or failure to meet some requirement of the court. All right? Versus being dismissed with prejudice. We all must understand that. So in light of that consideration, she said that the application for order to show cause while a preliminary introduction or temporary restraint be put on the state of New Jersey until the original complaint can be decided that was filed December 3rd, 2024. Okay? There is no order dismissing that complaint, but nonetheless, the complaint has been dismissed without prejudice, and we all know why, because we're going to see it in her argument, order. Right? Honorable, she is not honorable. Why? She's going to disqualify herself. Pursuant to the attached statement of reasoning. You know what? Malfeasance is right. Failure to act. Okay? Failure to act. Statement of reason. King Clifford Jefferson, see how she changed the caption? Because she don't want to deal with me from the represent political status in which I'm representing on behalf of our certificate of incorporation, which she's going to mention in the order, but she's going to not refer to that public record because if she do, she got to grant me everything I wanted to do. She's going to leave that up to the appellate court because they have the proper jurisdiction here. Why? Because they are courts of review. All right, and they reviews errors at law. Okay, errors at law or mistakes at law or mistakes in facts. Not because of opinion, but there was an error in some form of fashion. Okay? This order is only dealing with the order to show cause called the OTSC, order to show cause, which we call a core warranto. And the core warranto, which was implemented by me, was a result of the origin of where the core warranto stemmed from, going back to Quinn Imperators and the donors conditional bus, the statutes of entail, which the judge understands that even though she's gonna say she tried to glean what was going on, but she understood the ratification of what it was. I was arguing that if she granted it, it will be hell on earth. It would be it will what word she used. Um uh we're gonna read it for ourselves. All right. Procedural history and factual background. On December 3rd, 2024, King Clifford Jefferson, plaintiff, filed a complaint for a quiet title accompanied by an order to show cause against the state of New Jersey and the New Jersey Land Title Institute. In the complaint, plaintiff asserts that on April 18, 2022, he filed a certificate of incorporation of the Third Temple English Church of England, King and heir successors, as sole corporation. See how she switched the words around? Instead of corporation sole, she said sole corporation, which, based upon the common law, is one and the same, within the Middlesex County Clerk Office. So she recognized the certificate of incorporation, which is how our nation was incorporated, with the existing laws that were considered to be gone, forgotten, etc. All right? That's on the public record according to Title 47 of the public record, okay? Governing the public record. Let's see. Subsequently, on February 2024, plaintiff returned to the Middlesex County Clerk's office for the purpose of filing a religious deed, granting him the conveyance of the parcel of real or legal property from New Jersey by the authority of a ceremony called the Turf and Twig ceremony. All right, the Turf and Twig ceremony is called Lottery of Season. All right, plaintiff attempted to check in with the sheriff's officers at the front desk to the Middlesex County Clerk's officers using a religious identification card, which was not accepted by the officers because they got their own identification card, which is a standard ID, i.e., the driver license, or for some people, it's called just a standard ID, which identifies you. It doesn't prove who you are, just proves you to the level of identification in which they're under their presumption. The Middlesex County Clerk, Dawn Domino, arrived at the first floor of the building, met with plaintiff, and instructed plaintiff that she could not accept nor file the religious deed, but that she could accept a reformatted deed and accompanied by a seller's affidavit, buyer affidavit, and a seller's residency certification and exempt form. These are the forms given to third parties, okay? A seller or a lender is not the owner. Okay, they're a third party to claim to have an interest as a result of some security agreement, which resulted in some type of security interest, which is what we call a debt. Okay, creditor, debtor. We must understand that, but they are not the grantor because the grantor never told them to place those encumbrances on that property, i.e., property tax. All right. They must have authority to do so. And the only authority they got to do that from was the state through their incorporation. Okay? And a substantive right is a common law right that cannot be taxed, i.e., your natural person or the property that you hold as a natural person. Okay? Very important that you understand that. On February 21st, 2024, plaintiff returned to the Middlesex County Clerk's office with additional documents related to the filing of the religious deed and provided for the same to Dawn Domino on the first floor. Now she's going to forget all about the certificate of filing with the county clerk's office and go straight to the argument that was raised in the criminal complaint based upon their presumption that I did, in fact, commit a criminal offense by way of having a false instrument as well as having something to file upon a false instrument to file upon the public record, which was lawfully a necessity and justified under the same statutes that they used to criminalize me. Okay, which she totally ignored because nothing in this order that you're going to see based upon Title 39 of the revised statute governing the instrument they use to incarcerate me, arrest me, process me, etc. Okay, and that was the reason why the order, the so-called, should have been granted by the Chancery Court. But she know if she granted that, that means that everything else would have fell right in line. Okay, so she had to ignore everything that I was requesting in the so-called order to show cause, which was the state of criminal proceeding, stop all deeds being filed upon the county clerk, prevent all conveyances of any land that's on the allodial land, as well as stop all escrow accounts that were trusts created for those property interests, i.e., based upon the obligation that associated with actual security interests or security agreement. Okay, those are called escrow accounts. All right. So I asked for a stay until we can actually prove who owns what, who are the heirs, who are the foreigners, as well as establish under what law that they were supposed to be operating under, which is what we know as the common law of England. The common law of England, and our authority is based upon English legislative documentation. Once again, English legislative documentation and reception statutes, which were statutes incorporated in the state of New Jersey from the English legislative documentation, such as the Magna Carta, Bill of Rights, and everything else, the Clarendon Constitution. All right, these are all things that we depend on, not excluding the common law, which is what we call precedents, all right, to defend us in lieu of what we call our property right. Okay? All these things were ignored by the Chancery Court judge as a result of she understanding the what's at stake. All right? What's at stake, and you're going to see it revealed in this order. Right? On February 21st, 2024, plaintiff returned to Mrs. County Clerk's office with additional documents relating to the filing of the religious deed and provide the same to Dawn Media on the first floor. There's two ways you can convey land. One by way of law and one by way of deed. The deed was an actual instrument used to convey property, all right? And now the instrument showing proof of ownership. So when I filed the deed, it was only to show that a conveyance has been done based upon the Twicker Turk ceremony, which she mentioned, which is called lottery of season, which is done in two ways, by deed or by law. The conveyance was done by law. The deed was just the instrument showing proof of the conveyance by law, i.e. the damn statute. 46:3-6, 46:3-2, which is the common law statute governing all to be paid by. Let's read on. Plaintiff was indicted by a violation of a criminal statute for the use of a false government document, i.e. the driving license, specifically in plaintiff religious ID, i.e. a false government document, which was the so-called presumption of having a false deed, which is yet to be proven. Specifically, plaintiff religious ID. Additionally, plaintiff was indicted for a violation of New Jersey's statute, whatever the citation is, for offering a false instrument for filing. What makes your instrument better than our instrument? Okay, when your instrument clearly says on the face and under the statute that is not proof of one's citizenship or one foreign status, nor can it be used for an arrest, citation, charge, whatever it is that else you come up with. It cannot be used under the language of the statute, which she clearly leaves out completely within this order. Okay, because she relying on the criminal level to distinguish this matter before it even can get to the trial court, and that's not going to happen because of this appeal. All right. Presently, the criminal action docket is pro se file 24889 against plaintiff, remaining pending before Sheriff V. Pitchford, Justice of the Superior Court. All right. They're not honorable whatsoever. All right. All that's irrelevant. I'm not worried about that because that's going to be distinguished when we get there, which I got court December 3rd of next month. So it reads on December 9th, 2024, in the above captioned criminal action, the public defender assigned to the representative plaintiff, that goes into the argument that was brought on behalf of the public defender, which I don't want to even go into that. Let's move forward. Right here. Now before the court is plaintiff ordered to show cause seeking relief in a form of one, an interlocutory injunction in the criminal matter against him. Two, an order requiring New Jersey to provide evidence demonstrating that plaintiff is a New Jersey state citizen. Okay. Three, an interlocutory injunction to prevent the recording of any deed in the state of New Jersey pursuant to New Jersey Revised Statute 46:3-6. So I'm not just saying this shit. Excuse my French. I'm not just saying it. The statute says the land is allodial. And if the land is allodial, that means that there should be no encumbrances, no taxes, no easements whatsoever on allodial land. All right? That's what the statute said. They said, so I requested an interlocutory injunction to prevent from recording any deed in the state of New Jersey because why? The land is allodial as set forth by the statute. All right? She knew that. And this plaintiff seeks temporary restraint in the form of an interlocutory injunction to prevent the conveyance of any allodial land situated in the state of New Jersey. Why? Because the statute says the land is allodial. And if it's allodial, that means it should be free and clear from any encumbrances. Does that make sense to anybody who's watching this lecture right now? If so, please give me a thumbs up in the chat line. Give me a thumbs up if that makes common sense to you. Because apparently this judge don't have common sense. Two, an interlocutory injunction until heirs are confirmed to the land and such that title may pass directly from the state of New Jersey. And three, an interlocutory injunction for all income from adverse possession of allodial land in the state of New Jersey. All right, so that means that if the land is allodial, that means everything that mentioned prior to the land being allodial must be distinguished. I didn't say so. The statute says it. Okay? Very, very, very important for you to understand that. All right? The statute, New Jersey Revised Statute, Title 46:3-6, says that the land is allodial. Allodial means free from any encumbrances. Free from any encumbrances. The statute didn't say New Jersey owned the land allodial. New Jersey declared that the land is allodial, which means that New Jersey does not own it. So if New Jersey does not own it, then somebody has to own it. All right? But it can't be determined until a claim has been brought forth to quiet the title in lieu of who owns the allodial land. All right? And it can't be New Jersey because New Jersey insures defective titles, which is every title filed on that county clerk's office, which is the reason for a stay. All right? The Chancery Court knew that, but she said, I'm not signing off on this because, hell, they'll be at my front door. Present motion. On January 2nd, 2025, plaintiff filed an instant order to show cause. Foremost, plaintiff exhausts all references to the government of England and English common law and argues that interpretation of the Constitution of the United States is necessarily influenced by the fact that its provisions are framed in the language of the English common law and are to be read in light of its history. Okay? I didn't say that. This is what she said. Okay? So let's go through the appeal real quick. I didn't make that up. Everyone with me? Everyone didn't go to sleep, did you? All right. Certification. Preliminary statement. Every argument she brought forth in that order, we're gonna argue that before the appellate court. Preliminary statement, statement of the facts and procedural history, standard of review, legal argument, and conclusions. Okay? And conclusions. First argument. Plaintiff argues his position referring to English common law and English legislative documents that are inapplicable and irrelevant to this court and enforcement of laws of the state of New Jersey. That's the first thing she put her mouth in. Two, plaintiff has not demonstrated by clear convincing evidence that the request preliminary injunction will relieve him and prevent immediate irreparable harm. Okay? Three, plaintiff has not established that his underlying legal claim that he is not a New Jersey state citizen. 4. Plaintiff has not established his ownership of allodial lands in the state of New Jersey, as well as settle or establish a reasonable probability of success on the merits of those claims. How in the hell can I do that if you don't allow the defendants to answer the damn complaint? How can I do that? You stop that. All right? For no reason at all. You didn't show, based upon your review of the law, that what I was saying was a violation of the law in lieu of your analyzation. You never said that, because we're going to go back to the order and see that you don't. You only did it because of point 5. Let's read it. The court finds that defendants will face greater harm upon the issuance of plaintiff's request relief as to prevent New Jersey from recording any deed and would endanger its important functions of the state, disrupt the status quo, and would be plainly against the public interest. All right? So everything that was not in point 1, point 2, point 3, point 4 was only based upon point 5. Okay? To defend the state of New Jersey as a result of the status quo in which they are operating at this present, as well as the public interest in which involves their status quo, which is not based upon the citizens, nor the subjects, nor foreigners. Okay? It's based upon their kleptocracy. Okay? That's what it's based upon that, and we're going to prove it. All right? So this is what I'm arguing in the appeal, based upon what was stated in the argumental points raised here in points 1 through 5. Okay? But first, let's hear it from the horse's mouth. So I brought the issue up. She read in the order that the plaintiff exhausts all reference to the government of England and English common law and argues that the interpretation of the Constitution of the United States is necessarily influenced by the fact that its provisions are framed in the language of the English common law and to be read in light of its history. Okay? I'm going to pick through this. Plaintiffs raised and argued issues related to the criminal actions pending against him, specifically that New Jersey wrongfully arrested and charged him with the use of a false government identification card that plaintiff used a religious ID and is protected by the tort law defense of necessity and was justified under the English common law. Okay? That's what I'm saying. All right? But they use a false ID to arrest me, but I was protected by the religious ID, which is protected by the information filed on the public record, which supports the purpose and intent of why we have a religious ID. Okay? It supports that. Plaintiff continues that New Jersey has violated his common law rights by invasion of privacy and malicious prosecution. So all this is already known by the Chancery Court. Okay? And she knows that that's the purpose and intent for the order to show cause, why a temporary restraint should be done based upon what Title 39 of New Jersey Revised Statute says, which we're going to see in my appeal. Okay? She's not going to say it here because she knows it will be violation of malfeasance of office. Okay? As well as failure to render or provide equitable remedy at law. Okay? Under the common law of England, which the Constitution calls for. Okay? I'm not just making it up. The Constitution says it. Additionally, now remember, this case was dismissed with what? Without prejudice. If this state, what I'm reading right here was frivolous, he just dismissed it with prejudice. Okay? She should have dismissed this complaint without prejudice. With prejudice. She dismissed it without prejudice because she know I'm right. But she just didn't want to sign up on it. All right? We're going to see it. Additionally, in relation to plaintiff's attempt to file a deed on February 21st, 2024, plaintiff contends that defendants have committed adverse possession regarding allodial land in the state of New Jersey. As plaintiff states, land located in the state of New Jersey is the land of the Crown, and thus it may only be sold to the heirs of the Crown pursuant to the Estates Sales Act of 1285. If you look at New Jersey Revised Statute 46:3-15, it will mention the Entail Estate Act, which was abolished because New Jersey abolished the Entail Estate Act, which was an act to protect the land that belongs to you, the English heirs. Okay? She admitted it. She just don't want to deal with it because she knows it's true. She didn't say the statute. She just went to the actual English legislative documentation. Okay? She said, further, plaintiff states that New Jersey Revised Statute 46 46 on 3-6 provide him with the ability to take sovereign possession over unclaimed land by virtue of the monarch's claim. You damn real, because the land is sololio. And if you read 46 on 3-2, it says that all land, tenure, hereditament, etc., under the common law is held either by the King of England, body politic, corporate, or person. That's a corporation, so which she just defined as sole corporation. All right? She know what's up. The court, she states, has done their best to thoroughly review plaintiff's application in an attempt to glean the asserted claims and corresponding requests for relief. Due to the nature of plaintiff's filing that proved and has proved to be a challenging endeavor, it is well settled that pro se litigants are held to the same standard as an attorney. That is a complete lie. Why would you say that? That pro se are obligated to the same standard as an attorney. No, that's not true. That's another mistake you made. Therefore, like attorney, pro se litigants are prohibited from using the judicial system for the advancement of their own personal gains. All right? This is her argument, which is void. Why? Because you violated the law. You violated the law, but you said you claimed to thoroughly review plaintiff's application to attempt to glean and ascertain what it is that I requested for relief in lieu of the orders of show cause, let alone the actual original Chancery complaint filed back in December 3rd, 2024, which you dismissed as a result of you dismissing the orders of show cause, okay? And you dismissed it without prejudice. Come on, man. How plain can you see this? Let's get on with it. She used some type of close factor, which I'm not interested in. Let's look at the analysis. Before the court, it's plaintiff ordered to show cause seeking temporary restraint in the form of an interlocutory injunction to prevent the conveyance of any allodial land situated in the state of New Jersey. If the land is allodial according to the statute, why would you stop or prevent somebody who owns the allodial land to acquire it? If it's allodial, apparently it's owned by somebody. You just upset about who's claiming to have a right to possession of ownership, and not just right of possession by way of what we call adverse possession, which the state of New Jersey has proven that is how they interpret it, which is called prescription. 2, an interlocutory injunction until intel heirs are confirmed to the land and such that the title may pass directly from the state of New Jersey to those heirs. Okay? 3, an interlocutory injunction for all income from adverse possession of allodial land in the state of New Jersey. Okay? All that is rooted in 46:3-6. If the land is allodial, that means that nobody else is supposed to be on it except the owner. Except the owner. But who is the owner? It's not the state of New Jersey, or else they'll be able to show a clear chain of title. Okay? And that won't come with a deed. Deeds are color title. It will come from a letter pad with the crown seal on it. Okay? With the crown seal on it. The court looks to the factors laid out by the courts in Crowes versus Gioia to determine whether to grant injunction relief. Crowe provides that to obtain injunctive relief, the movement must meet 3 factors. The request relief must be necessary to prevent irreparable harm. 2, the movement's underlying legal claim is settled and that it has a reasonable probability of success on its merits. And 3, the balance of the relative hardship to the parties weigh in favor of granting the relief sought. Okay, so those are the 3 requirements that I must meet. Okay, I met all 3. The first one says prevent irreparable harm. If you go by the statutes on the Title 39, then I'm being harmed because every time they pull me over with that instrument, I'm being unlawfully arrested, which the statute says you're not supposed to do because it does not prove that I'm in fact a foreigner or in fact or a citizen or in fact anybody. Okay? It doesn't prove it. All right? Two, the movement underlying legal claim is settled that it has a reasonable probability of success on the merits. You didn't even allow that to come to fruition as a result of you dismissing the complaint. When the statute clearly says that the land can be conveyed by way of operation of law, i.e., the statutes, and not by some color deed filed in the county, which is only uh, um, uh, uh, presumes to have a right of possession, but not a right of acquiring possession due right of ownership. Totally different. All right. Two, the movement and underlying legal claims is settled and that it has reasonable probability of success on the merits. The common law establishes that. Okay? The English legal documentation establishes that. The balance of relationship hardship to the parties may be in favor of granting relief sought. Each must be clearly and conventionally demonstrated. How can I do that when you ignore the English common law of England, when you ignore the English legislative documentation? So how could you do what you said you did? She said she tried to ascertain, okay, what it is that I was asking for in my application. Okay. She said she tried to glean to assert what it is that I was bringing my claim about, and that was rooted in the English common law and the English legislative documentation, which she clearly ignored because she ignored the public record which those documentations were filed. Okay, which under Title 47 we have the right to examine. Okay, we have the right to examine. Let's move forward. All right, so it must be conventionally demonstrated. The court first examines the plaintiff's application for temporary restraint under the factors prescribed for an injunctive relief under the Crow standard and finds that plaintiff has not established the requisite burden by clear and convincing evidence. Okay? Not one statute to qualify what she's saying, not one precedent to qualify what she's saying, not one reference statute, constitutional amendment, constitution, legislative, anything to support her findings. Okay? This is just her opinion. Okay? This is just her opinion. She claimed that I haven't shown any prerequisite burden of clear, convincing evidence. The statute is evident enough. Plaintiff has not demonstrated nor argued that without the above mentioned interlocutory order, immediate irreparable harm will occur. I did so by establishing Title 39. Did you hear anything in her order about Title 39? No. Why? Because she made sure she did not, because that will prove that harm was being prevented as a result of how they're identifying me. Okay? It proves it, which ultimately now the appellate court has to interpret it since you neglected to do so. Okay? Plaintiff merely states that he is entitled to allodial land in the state of New Jersey. I didn't just state that. The statute stated it. The statute stated it. You just didn't know who it belonged to, and you're upset because I'm the one claiming ownership pursuant to the statute. So I'm not just making the statement. The statute says it in the very language of the statute. Next, plaintiff has not demonstrated that his underlying legal claim for ownership of entitlement of said land is well settled or establishes a reasonable probability of success on the merits of his claim. As plaintiff argues his position referencing English common law and English legislative documents that are inapplicable and irrelevant to this court enforcement of the laws of the state of New Jersey. Did everyone hear that? Did everyone hear that? She dropped a bomb. Plaintiff argues his position referencing the English common law, that's case law, and English legislative documentation, that's legislative enactments from Parliament, okay, as well as receptive statutes, which were statutes incorporated in the state of New Jersey. Why? Because she stated out of her mouth that they are inapplicable and irrelevant to this court enforcement of the laws of the state of New Jersey. Did everyone hear that? Please give me a thumbs up in the chat line. All right. So let's go to my appeal. appeal from the order to show cause. There was also a letter that I submitted as a result of finding out that there's no order for the original complaint that was filed. Okay, the order to show cause said nothing about dismissing the original complaint filed on December 3rd. Okay, but she took it upon herself to do so. All right, because she knows that if they did default on answering that chancery complaint, she would have to rule on it anyhow. Okay, so she made sure that she would not have to make that decision by dismissing it without prejudice. This is called prophecy. Okay, I'm seeing this before it actually happened. Okay, how many of you have the ability to be able to do this, to do that? Okay, so the first point she stated that plaintiffs argues the position referencing the English common law and English legislative documents that are inapplicable and irrelevant to the court's enforcement of the laws of the state of New Jersey. Okay? That's what she said in the order. Okay? That's what she said in the order. All right? So let's go to page 6. All right? Not one piece of case law, not one legislative statute, not one little bit of anything to support the findings of what she just stated in her court order. Okay, not one. All right, and now the judge have to find out what errors, mistakes she made at law, as well as errors in fact. Okay, you can't determine the fact until you determine the law. All right, because the law determines the applicability of the so-called facts, i.e., evidence. So let's deal with the first pronouncement of her order in regards to why she dismissed my not just the order to show cause, but the actual complaint. Okay, she stated in the order that the English common law and the English legislative documents are inapplicable and irrelevant to this court's enforcement of the laws of the state of New Jersey. So this is the first thing that the appellate court has to take a look at. Okay. Now she didn't leave them. The chancery court didn't leave the appellate court any wiggle room to actually save them. Because what did her order or her statement of reason for the order? What was it rooted in? What law was it rooted in? She didn't give you any law. Okay, in regards to why she denied why English common law of England and the English legislative documentation, all right, shouldn't be used in any decision in any court of the state of New Jersey. She did not give you any pronouncement whatsoever in that order. All right. So the order stated that the English common law and English legislative documents are inapplicable and irrelevant to this court's enforcement of the laws of the state of New Jersey. This is what she says, right? Appellate is in irreparable harm as a result of the order given by the Chancery Court to deny the appellant a common law remedy as established by the Constitution, statutes, and case law. The Constitution is clear pursuant to the common law of England, which clearly the Chancery Court has purposely overlooked to protect the actions of the state that do not pertain to the public interest of its subjects or its citizens. Okay? This is my argument, brothers and sisters. The Constitution of New Jersey, 1776, Article 22, is clear. It states that the common law of England, all right, as well as so much of the statutes at law that have been heretofore practiced in this colony should still remain in force until they shall be altered by a future law of the legislative. Such parts only except are that as are repugnant to the rights and privileges contained in this charter, and that the estimable right to a trial by jury should remain confirmed as a part of the law of this colony without repeal forever. Article 23. That every person who shall be elected as aforesaid to be a member of the Legislative Council or House of Assembly shall previously to taking his seat in Council or Assembly take the following oath of affirmation. I do solemnly declare that as a member of the Legislative Council or Assembly, as the case may be, of the colony of the state of New Jersey, I will not assent to any law, vote, or proceeding which shall appear to be injurious to the public interest or the public welfare of the said colony now called state. Know that should they annul or repeal that part of the third section in the charter of this colony, which establishes that the elections of members in the legislative councils and assemblies shall be annual, know that part of the 22nd section in that said chapter, in that said charter, not chapter, and that said charter, respecting the trial by jury, nor there shall null or repeal or alter any part or parts of the 18th or 19th section of the same. And as in any person or person who shall be elected as aforesaid is hereby empowered to administer the said ministers to the said oaths or affirmation. Y'all better listen to the gravity of the situation. Provided always in its true intent and meaning in this Congress that if a reconciliation between the Great Britain and these colonies should take place, and that the latter be again taken under the protection and government of the Crown of Great Britain, this charter should be null and void, otherwise remain firm and inviolable. That's two statute articles of 1770 Constitution that I used to defend in lieu of my appeal that the order she gave was void. Do everyone agree with me? Please give me a thumbs up in the chat line. Please give me a thumbs up in the chat line if you agree with me. While you do that, let's read the Constitution of 1844. Says New Jersey don't use that to establish any precedents in the state of New Jersey and in the court of the state of New Jersey, as stated by the Chancery Judge. All right? Let's look at what the Constitution of 1844 says that she totally ignored if you ignored the common law of England and the English legislative documentation. You ignored that. Constitution of New Jersey, 1844, it states that no inconvenience may arise from the change in the Constitution of the state, and in order to carry out the same into complete operation, it is hereby declared and ordained it is hereby declared and ordained that the common law and statute laws now enforced, now repugnant to this Constitution, should remain enforced until they expire by their own limitation or be altered or repealed by the legislature. And all risk actions, causes of action, prosecutions, contracts, claims, and rights of individuals in bodies of corporate and of the state, and all charters of incorporation shall continue, and all indictments which shall have been found or which may hereafter be found for any crime or offense committed before the adoption of the Constitution may proceed upon as if no change had taken place. Y'all better understand the weight I'm putting on this court. Constitution of New Jersey, 1947. Article 11, Section 1, Paragraph 3. It says that the Constitution should supersede the Constitution of 1844, okay? Which incorporated what? The common law of England, as well as the common law precedents, as well as the common law legislative documentation, which she claimed that the court don't honor. That's now what the 1947 Constitution just said, while we're reading it right now. You didn't read it, but the appellate court will read it when they read this appeal. 2, that the legislature shall enact all laws necessary to make the Constitution fully effective. 3, all laws, statutory and otherwise, all rules and regulations of administrative bodies and all rules of course enforced at the time of this Constitution or of any article thereof takes effect shall remain in full force until they expire or are superseded, altered, or repealed by the Constitution or otherwise. All right, or otherwise. All right, that's just what the Constitution says. Let's look at some legal precedents under the common law of England. All right, let's look at what Smith versus State versus Smith say. All right, if all three constitutions of New Jersey honor the common law of England, as does the appellants, then it is not the public interest that the court seeks to protect. It is their practice of kleptocracy at the expense of the common law of England. You hear that? They're playing and doing everything at the expense of the common law of England. I didn't say that. The Chancery Judge just said that. All right? Without any citation of the Constitution, right? Without any statutory reference or anything used to justify such an order. Nothing. The court said it does not. It's best. The court said it has done its best to thoroughly review plaintiff's application, but this is impossible without the guidance of the common law. State versus Smith states that the common law of England, as well as so much of the statutes at law as has been heretofore practiced in this colony, shall still remain in force until they are altered by the future law of the legislature, such as established in all these constitutions that we just read. And all three constitutions that we just read, they're saying the same damn thing in the Supreme Court of New Jersey 1981 case in State versus Smith. Okay? In State versus Smith. All right? They also say it in what? Bellin versus Harris. Barbage versus Barber. They say it right here as well. Supreme Court, New Jersey. Before discussing the effect of the express words of the Constitution, we should explore the possibility of the original jurisdiction and the Superior Court acquired from a superseded court to whose power it is the successor. The only court through whose power such an inherited jurisdiction could come would be the former Supreme Court of New Jersey. Article 22 of the 1770 Constitution provided that the common law of England, you hear that? We just read all this in the Constitution. We just read this in State versus Smith. We read it in Barber versus Barwick, okay? Barber versus Barber, okay? And all this is rooted in what? The King's Bench, okay? I'm not going to read it all for the sake of what I got to cover today, all right? Right here. Barber versus Barber. It has been held that by the conjunction of the Ordinance of the Lord Cornbury Act enacted in 1704, other ordinances, including those ordinances in 1714 passed by Governor Hunter and his council, the 1776 Constitution, the Statute Super of October 2nd, 1776, and the Constitution of 1844, the former Supreme Court became vested with the ordinary common law original jurisdiction of the courts of the King's Bench, shared to some extent by the county circuit courts and the courts of common pleas, and that it became more exclusively vested with the appellate and extraordinary jurisdiction of the English courts. You hear that? So how are we going to lose with this argument? It said it in the Supreme Court of New Jersey. They even say it in Bellin versus Harris, which is the district court qualifying the very same thing that we're saying. Okay? Which is absent from her order. Bellin versus Harris says the very exact same thing. Okay? So that alone warrants reversal of void of that order and reversal back to the Chancery Court, and to allow the defendants, if they don't go into default, by way of me motioning the court to modify the order and allow the defendants to respond to the actual quiet title, since there was no order filed for the record in lieu of the closing of the case at the court in lieu of the court's disposition on January 1st, 2025, January 16th, 2025. Okay? Very, very important you understand what's going on. Let's go back to the civil case order given by Judge Vignulo. Let's go back there. We're on page 7. So he said, further, the court finds that in the balance of relative hardship on the parties, the harm to the defendant will be greater than the harm to the plaintiff. So they're saying that as a result of granting the order so called, that the state of New Jersey will be in more harm than the defendants who filed the complaint as a result of them being in harm, i.e., and what they call a state of emergency. All right? They're saying that the defendants are in greater danger. Let's see why. It's not going to be supported by any case law, any constitution, any so-called statute whatsoever on the reason why she denied everything I requested in the order to show cause, which is also rooted in the original complaint that was dismissed without prejudice, which means that it has some validity. She's just not going to review it. Okay? So she said, therefore, plaintiff's application is temporary restraints is denied. Why? Because they said, further, the court finds that in balancing the relationship hardship of the parties, the harm to the defendant would be much greater than the harm to the plaintiff. A broad restraint on New Jersey and the Land Title Institute to prevent the conveyance of all allodial land in the state of New Jersey would disrupt the routine functions of New Jersey and stifle all conveyances regardless of relation to this present matter. I repeat, further, this court finds that if in balancing of the relative hardships of the parties, the harm to the defendants would be much greater than the harm to the plaintiff. A broad restraint on New Jersey and Land Title Institute to prevent the conveyance of all allodial land in the state of New Jersey, even though the state of New Jersey and Land Title Institute don't own it, even though they can't prove they own it, because why? Land Title Institute ensures defective titles and property that are in possession of those acquired by way of a deed. Okay, so the court's decision is only for the purpose and intent to restrain the harm that will be caused upon the defendants, then versus the harm that will be done on the plaintiff, i.e., the English heirs and successors who own the land allodial via operation law by way of the statute. All right, but she don't give a damn about what the statute says. Why? Because they're using it right now and to keep up the status quo. Okay, so it says, I repeat again. Further, the court finds that in balancing of the relative hardship of the parties, the harm to the defendant would be much greater than the harm to the plaintiff. A broad restraint on New Jersey and the New Jersey Land Title Institute to prevent the conveyance of all allodial land and the state of New Jersey would disrupt the routine functions of New Jersey and stifle all conveyances regardless of the relation to the present matter. The court is steadfast in its finding that the granting of such relief will harm the public interest at large. Therefore, plaintiff's application for temporary restraint is therefore denied. Okay? It's denied. Why? Because of the harm that might come to the defendants if she followed what the law said. If she followed and did exactly what the Constitution said, what the President said, what the statute said, then this will put New Jersey in harm because they are in violation of the law, which calls for an injunctive relief, which was denied by an incompetent judge. Okay? Do everyone agree with the statement I just made? Please give me a thumbs up in the chat line. Plaintiff seeks collateral attack changes. Plaintiff seeks to collaterally attack changes pending in the criminal matter against him before Judge Cherie V. Pitchfork. The court is constrained to deny plaintiff's request for an injunction in a separate action that is an ongoing and arguably raises claims that should be asserted in the active criminal case. Additionally, plaintiff has not demonstrated by clear and convincing evidence that the requested preliminary injunction relief will prevent immediate irreparable harm. Plaintiff does not present any evidence to establish the immediate irreparable harm will occur in any circumstances. Moreover, plaintiff has not established that his underlying legal claim that he is not a New Jersey state citizen, nor as stated above, his ownership of the allodial land in the state of New Jersey is well settled or established a reasonable probability of success on the merits of those claims. Okay? All this is her belief. Plaintiff contends that he is an English national and king of the English nation, but provides no evidence other than a religious ID. That's a straight up lie because the public record clearly establishes and shows the authority that I'm operating, which is a necessity and is justified. Okay? So she's clearly a liar because she's don't rely on the. 1 second. Move. So she's only relying on uh, the criminal report on the and that was filed and the criminal action which was unlawfully filed against me based upon the language of the said statute, Title 39, colon 3-29.3. Okay? We must understand that. All right. Likewise, plaintiffs have not shown clear convincing evidence that he's entitled to ownership of said allodial land to warrant the court to grant an injunction to prevent the recording of any land deed in the state of New Jersey. Well, if that was the case and it was frivolous, why did you dismiss it without prejudice? Okay? Plaintiff only asserts that he had acquired ownership through a twerp and twig ceremony. Hell, William Penn did it too. You ain't say nothing to him. You ain't say nothing to him. Okay? Plaintiff only asserts that he acquired ownership through the twerp and twig ceremony utilized by the English common law, which you said has no place in the courts of New Jersey, which the Constitution says different. Okay? Finally, the court finds that defendants will face greater harm upon the issuance of plaintiff's request relief as to prevent New Jersey from recording any deed and would endanger important functions of the state, disrupt the status quo, and would be plainly against the public interest. Okay? Therefore, for the foregoing purposes, plaintiff's application for temporary restraint and plaintiff's order to show cause seeking preliminary injunction relief is denied. Okay? We all see why she denied the order to show cause for preliminary injunction. All right? But she doesn't justify, based upon law or fact, why it was denied. Because everything we see here is based upon her opinion that I didn't raise a good enough argument or didn't provide enough evidence based upon you ignoring the evidence as well as the arguments that were provided under the English common law and the English legal precedents that was provided to you, as well as the statutory law, which you clearly ignored, but claiming to even try to glean of what it is that I was asking for relief. How can you do that without the aid of the common law of England? How? How can you do that? Let's go back to the appeal. That part right here. Talking about the King's Bench, Barber versus Barber, Bellin versus Harris, State versus Smith, the constitutions of all three constitutions all qualify that we have a sound argument to raise before the appellate court. You two cut it out. Leave him alone. Go play. Two, court order. Plaintiff has not demonstrated by clear, convincing evidence that the request preliminary injunction relief will prevent immediate irreparable harm. Okay? I've done that. By you denying the common law of England and the English legislative documentation, we're in harm. Appellant has shown that irreparable harm has been caused on the grounds that New Jersey has presumed that I am not an English national protected by the common law of England. Law subsequent Pretorius and Core Warranto order to cause was passed by the English kings of England, who we are the heirs and successors of, as provided by the statute, Title 46-3-5 and -15. Okay? And under the Core Warranto, which was also passed with King Pretorius, which was law against subjugation of land that New Jersey has now in their possession, but can't prove they own it. Okay? They can't prove they own it, but now they're forced to show if they own it by showing that they have a clear chain of title, which they cannot do because why? They're not owning land under the English common law of property rights. Okay? Which they borrow. They're using, but ain't English. How can you do that and not be English? All right? Let's go to another argument. I got all grounds covered, brothers and sisters, right here. Court order plaintiff has not established that his underlying legal claim is that he is not a New Jersey state citizen. Okay. Everything else I can prove if they honor the English common law of England, all right, as well as the English legislative documentation. If they honor that, I can prove everything I'm saying. Okay. But they don't want to honor the English common law or the English legal precedent because that determines my political status. They want me to have the civil status as established under Title 39, colon 3-29.3. In your case. You see I'm doing the best. What's your problem? Stop it. In there. It says plaintiff has provided proof that he is not a New Jersey state citizen as established in the Dorn statute. Okay? Plaintiff has provided proof that he is not a New Jersey state citizen as established in New Jersey by statute 39 colon 3 dash 29.3. The Chancery Court has intentionally ignored the language of this statute to protect the kleptocracy interests of the state of New Jersey under New Jersey by statute 59 colon 1-1, which is the seat of government that they now reside in Trenton, which is only temporary as provided by the statute. Okay? The purpose of intent of such a statute has nothing to do with the applicant's status or standing in law. In fact, such an instrument establishes the opposite of the appellant's status and standing under color of law. If we read the language of the statute under 39 colon 3-29.3, it clearly says that any documentation, personal information, including applicant's photograph obtained by the commission for the applicants for the standard identification card should be confidential and not be considered part of any governmental record or under the common law concerning access to government records. Did y'all hear that? That's what the statute says, brothers and sisters. That's what it says. All right? I didn't make it up. The statute says it. Under 39 colon 3-29.3, it says that instrument should not be considered evidence of individual citizenship or immigration status. It should not be used as a basis for an investigation, arrest, citation, prosecution, or detention. She knew that, okay? She knew that, but that's what they're using it for, which is a malicious prosecution. The state used this statute to commit this malicious prosecution on the plaintiff, who is the applicant in this brief, by improperly identifying the plaintiff and arresting and prosecuting the plaintiff under the false identity. United States versus Juan Kim Ark, the Constitution nowhere defines the meaning of these words, either by way of inclusion or exclusion, except insofar as that it is done by the affirmative declaration that all persons born or naturalized in the United States is subject to the jurisdiction thereof, and are citizens of the United States, such as Juan Kim Ark, okay, such as the Attorney General Master J. Plankin. But our citizenship is not based upon how they determine citizenship. Our status is based upon our subjectivity to the crown under the laws of the crown, which is the common law of England. And that is, in other respect, based upon United States versus Juan Kim Ark, it states that, in this, as in other respect, it must be interpreted in light of the common law and principles and histories of which were familiarly known to the framers of the Constitution. They didn't use that common law. They used the Naturalization Act of 1790. Okay? They didn't even use the common law. Okay? Because it did not pertain to them. All right? Just as the State versus Smith, we also see it in Smith versus Alabama. Mr. Justice Matthews, delivering the judgment of the court, said that there is no common law of the United States in the sense of a national customary law distinct from the common law of England as adopted by the several states, each for itself, applied as its local law, and subject to such alteration as may be provided by its own statute. Do y'all hear this? All right. So what justifiable reason did the court have for denying my order to show cause? If you read it right here, based upon the protection you have under the common law of England, which is a law that was incorporated in every local law of every state within the United States, based upon the state's constitution, the United States Constitution. There is, however, one clear exception to the statement that there is no national common law. The interpretation of the Constitution of the United States is necessarily influenced by the fact that its provisions are framed in the language of the English common law and are to be read in light of its history. You hear that? Of its history. The fundamental principles of the common law with regard to English nationality was birthed within the allegiance, also called legality, obedience, faith, or power of the king. The principles embrace all persons born within the king's allegiance and subject to his protection. You hear this? You see where this is going? You see where this is going? Children born in England of such aliens were therefore natural born subjects, but the children born within the rim of foreign ambassadors or the children of alien enemies born during and within the hostile occupation are part of the king's dominions were not natural born subjects because not born within the allegiance, the obedience, or the power, or as will be said at this day, within the jurisdiction of the king. The law of England and almost all civilized countries ascribe to each individual at birth two distinct legal statuses or conditions, one by virtue of which he becomes the subject of some particular country, binding him by that title of natural allegiance, which may be called his political status, and another by virtue of which he has ascribed to him the character of a citizen of some particular country. All right, and as such is possessed of a certain municipal right and subject to certain obligations, which the latter character is the civil status or condition of the individual and may be quite different from its political status. Did everyone hear that? Did everyone hear that? Okay, yeah. Juan Kemart. Now we read about that. Matthew J. Plankin mentioned that, but his mention of United States versus Juan Kemart had nothing to do with the English common law or those who determination of citizenship should be determined based upon or subjectivity were based upon the English common law, which the court clearly ignored in this matter. Okay, which affords us no due process of law. Okay. As a result of that, we are afforded no due process of law, which is a violation of law, which is grounds for what? Everyone said, an appeal. All right, an appeal. So we see what United States versus One Mark says. We are allegiance to the king. All right, so therefore we're protected to the king as subjects in the king's realm. All right, versus how they construe citizenship based upon you being considered a naturalized citizen by way of the process of residency. Okay, and if you're a resident, you can be taxed. Let's see. It's 341. Another point I'm going to talk about. Court order. The plaintiff has not established his ownership of allodial land in the state of New Jersey, is well settled, or established a reasonable probability of success on the merits of those claims. That's what she said. Let's look at that. In America, system of law, people having substantive rights are called common law rights that existed before and are protected by the New Jersey Constitution under that common law. Substantive rights as such are not taxable. You may not be taxed for the words you say, for the hands at the ends of your arms, or for the property that you own. Then they say taxation without representation is a violation of law. Okay. In order for a government to lay a property tax, i.e., property tax, it first must be certain that the property being taxed is not owned by the possessor. Okay, including you. If they taxing you, then you don't own your body. Okay. If you pay income tax of any sort, then you don't own your own body. All right. Everybody pay taxes, right? It says that having title to your property here and now in what we call North America is not full ownership of your property, including yourself. Titles only proves your right to possession, to use the property. Okay? That's called an easement. To have full ownership of your property, you must complete transfer process by obtaining what? A letter patent, an agreement or a contract that's granted from the grantor to the grantee, not from a third party such as a lender or a seller. Okay? We must understand that. They ain't giving you land patent. They're giving you deeds. Okay? That's what they're giving you. Having a land patent proves your allodial ownership of the land. Allodial signifies ownership without limitation, okay, i.e. encompasses. Once you have your allodial ownership of your land, you now can possess it with a matter of common law right. Common law right may not be taxed because so few know about this. Now the government is now free to define the term title as evidence of right of possession contrast to right of ownership. And now New Jersey purports that the true holder of the allodial title is now the government of the state of New Jersey, which is now being questioned by this lawsuit. Okay? That's what they construe. Let's go here. As I come to my closing. United States Supreme Court, New Jersey versus Delaware. The title to the soil which was subject to the just publican while it was vested in the king and his grantees is subject to the same restriction in the ownership of Delaware. All right. The patent and the deeds under it are not void for one of power. The question remains whether some other and better chain can be brought forward by New Jersey. Unless this can be done, Delaware must prevail. We know Delaware was declared by William Penn, who used the same damn ceremony, i.e., the twerp and twig ceremony. Same ceremony, but he didn't use lobby of law. He used lobby of deed. Okay? But down to the peace treaty of 1783 at the end of the revolution, New Jersey has no chain to offer. You hear this? They don't have a chain to offer. Up to that time, if not afterward, her reliance is less upon what? The strength of her own title than on the weakness of her adversary. All right? The supposed effects have already been revealed in this opinion and have been found to be unreal. There is still to be considered whether events during the years of statehood have worked a change of ownership. New Jersey argued that they have, though not even during those years. Pardon, let me read this again. New Jersey argued that they have, though not even during those years, does she build her claim of title upon an instrument of record. Her claim is rather this that through the exercise of dominion by reverend proprietors and by the officers of government, title to subsequent soil upon the center of the channel has been developed by what? Prescription. You hear that? I didn't say that. The case law said that. By prescription, which is the easement of non-possessory right to use or to enter onto real property of another without actually possessing it. You can't get no better than this, brothers and sisters. You can't. The king was a true and competent owner, giving him the authority to take and grant the land from the people in his kingdom who either lost or gained his favor. The authority to take the land may have required a justifiable reason, but such a reason can only be conceivably have been fabricated by the king himself. Conceit has been fabricated by the king, leaving the deceased former holder of the land wondering what was it that brought the king's wrath to bear upon him. This is what's happening now. All right, this is exactly what's happening now. At the same time, the beneficiary of such a gift, while undoubtedly knowing the circumstance behind such a gift, may still not have known how the facts were discovered and not knowing how such facts occurred, i.e., a gap in chain of title, may have been left to wonder if the same fate awaited him if ever been fell into disfavor with the king. Okay, so this is a trend effect that's going to be a domino effect in regards to you falling out of favor with the king's process of how you are to acquire possession and ownership of land. If everyone understands that, please give me a thumbs up in the chat. Okay? Please give me a thumbs up in the chat because the deed is not a proper form of ownership. It's only an instrument of conveyance or possession. Okay? And if you didn't get it through the grantor, i.e. the king, through a letter patent, then that means you don't have a right to ownership. Okay? You don't have a right to ownership. Let's move forward. I cover everything, brothers and sisters. The fiefs were built in the same manner as a pyramid with the king. Notice the dollar on the pyramid, okay? The pyramid, it represents the feudal system with the king on the top who gets all common soakage, okay? We must understand that. All right. The fiefs were built in the same manner as a pyramid, with the king, the true owner of the land, being at the top. And from the bottom up, there exists this system of small to medium sized to large sized estates on which the persons directly beneath one estate own homage to the lord of that estate as well as to the king. At the lowest level of this pyramid, through at least the 14th to 15th century, existed to serfs or villains, the class of people that had no right and were recognized as nothing more than real property. Okay? That's what you are to the states, i.e., the United States. Property, my brothers and sisters. How I know it, let's read it for yourselves. The state position is the base system of land ownership today consists of three key requirements. The three are the warranty deed or some other type of deed purporting to convey ownership of land. Title abstracts or chancery abstracts are used to chronologically follow the development of these different types of deeds to a piece of property, and then the title assurance to protect the ownership of that land, i.e., the property that sits on the land. It don't protect the land, it protects your interest in the property because the land belongs to the one who owns it through letter pad. Okay? These deeds include as follow: warranty deeds, quiet claim deed, sheriff deed, trustee deed, judicial deed, tax deeds, rig or any other instrument that purportedly conveys the title. All of these documents state that it conveys the ownership to the land. Okay? It conveys the ownership. We know ownership and possession is two different things. Each of these, however, is actually a color of title. G. Thomas title to real estate property, preparation and examination of abstract titles. A color of title is that which is in appearance is a title, but which is reality is not title. Did you hear that? White versus Madison. In fact, any instrument may constitute color of title when it purports to convey the title of the land as well as the land itself, although it is void as an emolument of title. Joplin Brewing Company versus Payne. Okay? Case law. The Supreme Court majority has stated that when we say a person has a color of title, whatever may be the meaning of the phrase, we express the idea at least that some act has been previously done by which some title, good or bad, to be a parcel of land of a definite extent and has been conveyed to him. All right? St. Louis versus Gorman. In other words, a color of title is an appearance or apparent title, an image of the true title. Hence, the phrase color of title, which when coupled with possession, purports to convey the ownership of the land to the purchaser. You hear that, brothers and sisters? Do you hear that? I'm not saying this. This is case law. That's why allodial land belongs to the king, because anything filed on the county record based upon the deed, it's color a title. It does not prove the ownership because it's a gap in the chain of title, and that's why you have title insurance. Okay? That's why you have title insurance to insure against defects in the title, which means a gap in the title, which means a cloudy title. All right? This, however, does not say that the color of title is the actual and true title itself, nor does it say that the color of title itself actually conveys ownership. All right? Because it actually conveys ownership. So the title itself actually, this, however, does not say that the color of title is the actual and true title itself, nor does it say that the color of title itself actually conveys ownership. Okay? In fact, jumping. In fact, The claimant or holder of a color of title is not even required to trace the title through the chain down to his instrument. All right. Rather, it may be said that a color of title is prima facie evidence of ownership of any right to possess of land until such time as that presumption of ownership is disproved by a better title or the actual title itself. Okay. So anybody can put a lien on a property if they came and have a better interest on the property. You got a legal interest and an equitable interest. We have a better interest in equity than we have legally, which is being uh, uh, pacified and occupied by the state of New Jersey through the process of how they convey property, which is through what everyone said, color of title. Color of title. If such cannot be proven to the contrary, the ownership of land is assumed to have passed to the occupier of the land. To further strengthen a color of title holder position, courts have held that the good faith of the holder to the color of title is assumed in the absence of evidence to the contrary. Okay, so you good until somebody else challenges. Okay, which with such knowledge of what a color of title is, it's interesting what constitutes a color of title. A warranty deed is likely any other deed of conveyance. All right. A warranty deed or deed of conveyance is color of title, as stated in Doomsday versus Burns. All right. Doomsday versus Burns. It constitutes color of title. See also Drading versus Newman. A deed that purports to convey interest in the land is color of title. Hinckley versus Green. A deed which is on its face purports to convey title constitutes a claim in color of title. Bush versus Halston. A quiet claim deed is a color of title as stated in Stafford versus Stubbs. And McLean versus Kellogg. And see also Holloway versus Clark and McSellen versus Kellogg. Quick claim deeds can pass the title as effectively as a warrant with full conveyance. See Grant versus Burnett, Morgan versus Clayton, Bradley versus Brock, Butterfield versus Smith. Sheriff deeds also are considered color of title. See Kendrick versus Latham. I'm going down the line, brothers and sisters. As it is the judicial deed, Hood versus Boulton. The Illinois Supreme Court went into detail in determination that a tax deed is only color of title. There, the complainant seemed to have relied upon the tax deed as conveying to him the fee, and to sustain such a bill, it was incumbent on him to show that all the requirements of the law had been complied with. A simple tax deed by itself is only a color of title. Fee simply can only be acquired through adverse possession via payment of taxes. Claims in colors of title plus 7 years of payment of taxes. Thus, any tax deed purports on its face to convey title is a good color of title. All right? I'm not making this up, brothers and sisters. A good color of title. Walker versus Converse. Pedro versus Carricker. Chicago versus Middlebrook. Piatt County versus Gordon. Stubberfield versus Borders. Coleman versus Billings. Whitney versus Stevens. Thomas versus Eckworth. Holden versus Clark. It will pass only a color. A will passes only a color of title. Now they're talking about wills. Baldwin versus Ratcliffe, Bradley versus Reeves. A will can pass only so much as the testator owns, though it may attempt to pass more. A trustee deed, a mortgage in strict foreclosure, Chickens versus Fells, or any document defining the extent of a deceasor claim or purports a claim, Cook versus Norton, all have been held to be color of title. Okay? All have been held to be what? Color of title. In fact, there is nothing here requiring a deed to even establish a color of title, and under the former decision of this court, color of title may exist without a deed. You hear that? It may exist without a deed supported by other case law. All right? All these cases being still valid and none being overruled, in effect, the statement in these cases are well established law. All of these documents described in these cases are the main avenues of claimed land ownership in America today. Yet none actually conveys the true in the allodial title, then in fact conveys something quite different. Okay? So how am I wrong? Based upon what the statute says doing in regards to the land being allodial. That means that all the conveyances that are being done are nothing more than color or title because they don't prove you own it. The only person who can own it is own it free and clear, free from encumbrances, i.e., which means it can't be by prescription. All right, or adverse possession, eminent domain, or any other process that you come up with. All right. So in closing, the fifth part. Court ordered that the court finds the defendant will face greater harm upon the interest of plaintiff's request relief as to prevent New Jersey from recording any deed and would endanger all important functions of the state, disrupt the status quo, and would be plainly against the public interest. Everyone better pay attention. Against the public interest. Public interest law refers to legal practices undertaken to help poor, marginalized, or underrepresented people or to effect change the social policies and the public interest are not for on not for profit terms, okay? Often in the field of civil rights, civil liberties, religious liberties, human rights, okay? If this definition be true, that would mean that the Court of Chancery is obligated to protect the appellant's civil rights, civil liberties, religious liberties, human rights under the common law of England. Can everyone agree with that? The order, Brunsville. Now look what the statute said, brothers and sisters. The order of the Chancery Court stated that they are not bound by the English common law and English legislative documents and that are inapplicable and irrelevant to this court's enforcement of the laws of the state of New Jersey. We already qualified it in the Constitution. We already qualified it in stare decisis. Now it's qualified in what we call the reception statutes, which were statutes from parliamentary legislation of England's English law and to what we call the state statutes. Okay, to show them that the order of the Chancery Court judge, which we read majority of it in its entirety, didn't mention anything about the Constitution, nothing about any prejudice, nothing about any statute in which her order should be dependent on, which makes it grounds for a good appeal. So it says the order from the Chancery Court stated that they are not bound by the English common law and English legislative documents, which are inapplicable and irrelevant to this court's enforcement of the law of the state of New Jersey. How can this be when all three constitutions preserve the English common law and English legislative documents in their constitution? How can that be, brothers and sisters? The New Jersey Revised Statute 46:3-2 is clear. All right, it is clear in the statute, which you see in the order, she did not mention it. She didn't want to mention it, but she know when the appellate court get to it, they got to review it because this is, in fact, the language of the law. The New Jersey Revised Statute 46:3-2. I didn't write it, brothers and sisters, so don't be biased towards me. States that all tenants of honors, manors, lands, tenements, or hereditaments are under the state of inheritance as the common law. So why are you saying you don't honor the common law when all these constitutions honor the common law? The stare decisis that I presented honor the common law, and now we got the statutes governing property honoring the common law of England of how land is conveyed, lieu of possession, and ownership. Held either of who? The King of England or any other person or body of politic or corporate. At that time, before they even started their way of acquiring possession of land ownership. All right? Going back to July 4th, 1776. And still back then, it was still subject to common soaking. I repeat, it states that all tenures of honors, manors, lands, tenements, or of hereditaments, or of an estate of an inheritance at the common law of England, held either by the Kingdom of England or any other person or body of politics or corporate at any time before July 4th, 1776, are subject to common soaking. If she would have read that in Chancery Court, there would be no problem granting us what we wanted. Why? Because under the revised statute of New Jersey 46:3-6, it clearly states that all gifts, grants, or conveyances made prior to and after July 4th, 1776 are estates of inheritance by letter patent only under the great seal of the state or any of manner by the state or by legislature thereof or by any commissioner or agents of the forfeited estate or by any lawful and competent authority under the state shall and remain what? Elodial and not feudal and shall forever be and continue in free per elonium forever, discharged of all fetal tenures and the instances thereof, and all other services whatsoever. That's why the case law said they were all color of title. This is confirmed by New Jersey by statute 46-1. That the fetal tenures estate and the interest thereof taken away and discharged are abolished all the way back to the monarch of the House of Stuart, Charles II, because he gave the charter to Duke of York, who gave it to the Pamphleteers, which was submitted back to the crown in 1702, which you see mentioned here under what they call His Majesty's Council, New Jersey Provincial Council, and New Jersey Province of New Jersey. Okay, under the common law of New Jersey, under the Constitution of New Jersey of 1776. Okay, of 1776. There's no disputing this, brothers and sisters. So, in closing, Lisa M. Vignulo, I'm not even calling her a judge or honorable, uh, uh, order issued on January 16th was entirely rooted in the identity of how the state identified the appellant with the instrument called a driver license. His Majesty was arrested, fingerprinted, and booked by the sheriff's officers, searched and seized of his personal property. That includes the land that he was trying to revert back to the heirs who were held to do intel without just cause. His Majesty was also confined to a freezing dungeon-like cell or prison. His Majesty was forced to strip naked and bend over and cough. His Majesty was then given one pair of socks, one pair of underwear, one T-shirt with a thin blanket, and two thin sheets, and served rations of food that a hungry dog would turn his nose off to. All right, would turn his nose off to. Simply put, modern day slavery at its best. All right, the irreparable harm resulted from the use of the standard identification card called New Jersey driver license, pursuant to New Jersey by statute 39:3-29.3. When possession of that standard identification card issued pursuant to the section should not be considered evidence of an individual's citizenship or immigration status, and should not be used as a basis for investigation, arrest, citation, prosecution, and detention. And this is why that so-called order to show cause should have been instituted, and that the defendants have been allowed to respond to the allegations that were raised in the quiet title complaint once and for all, to settle who and once owned this land. Okay? So we see in conclusion, New Jersey by statute states under Title 52:1-1 that the state of New Jersey, i.e. Trenton, is the county of Mercer and should be the seat of the government of the state of New Jersey, which must conform to its Constitution of 1776, Article 22, Article 23, 1844 Constitution, Article 10, Section 1, and the 1947 Constitution, Article 11, Section Paragraph 1, Section 1, Paragraph 3, Paragraph 4, and Paragraph 5, which all incorporated the common law of England. The Supremacy Clause of the United States and the United States Constitution states statutes, including those found in Title 52, cannot violate the state's constitution. Any state law that conflicts with the higher legal authority is considered void and unenforceable. Lisa M. Vignulo, PGA, Chancery Order is void of if English common law and English legislative documentation are inapplicable and irrelevant to this court enforcement of the laws of the state of New Jersey. Appellants only bequest an injunction on the criminal proceeding in lieu of the appellate court review of this entire matter, and that the removal of Lisa M. Vignulo be removed from this case. So I only asked for a stay in lieu of the criminal complaint because I know that it will be hard to give that decision in lieu of what was argued in the Chancery complaint, which need to be reopened as a result of the invalid orders given in lieu of the dismissals, in lieu of the orders so-called, as well as the actual Chancery complaint itself. So there you have it, brothers and sisters, and full details that they have not stopped our flow, they just slowed it down a little bit, but rest assured that victory is assured in the end. So with that, I'm going to greet you how I meted you, and that's always in peace and love. And that's under oath, my brothers and sisters. So with that, peace.